So what spurred this? We'll put a link here. There was recently, I saw a post on Facebook from a police department in Connecticut, and at a safe driver checkpoint, I don't know exactly what that means in Connecticut, they noticed that a guy had an expired tag, expired registration, and in the process of that stop for expired registration, they discovered in his car that he had a bunch of prohibited weapons in the state of Connecticut. He's facing a whole bunch of felony charges here. And the first thing that came to my mind was, whoa, man, was this guy's constitutional rights abridged, or were they run roughshod over in this issue? So, Mark, can you give us an overview of how the Fourth Amendment applies to being searched as a firearms owner?
Wow, that's a big question.
Yeah, it's a lot, man.
We spend a lot of time on that in the law school exam, or in the law school setting. But, well, I guess you start from the beginning, right? I mean, what the Fourth Amendment is about. The Fourth Amendment basically protects your right. It really codifies an existing right. Because if you're talking about our founding fathers, they're all going to say, none of these rights come from the government, none of them come from the Constitution.
Wait a minute, let's say it again. The Constitution does not grant rights.
That's true.
The Bill of Rights in particular protect rights that are God-given rights. Go ahead.
Yeah, I mean, to step it back even more, many of our founding fathers read John Locke. And John Locke is a natural rights philosopher, and what he's saying is people have rights. You just have certain rights, independent of government. And so when we institute the government, the concept here is we're instituting the government for a reason, and the reason is to protect the rights that we already have. So all we're doing is we're enumerating, we're stating what some of these rights are. And this was some of the argument about the Bill of Rights. There was a big argument we didn't need it, which frankly is the one I would have signed on to. Then there's the argument, well, if we're going to have it, we should have the 9th and the 10th, because we don't want people thinking just because we listed this is everything, because it doesn't say a lot of other things, right? So
9th and 10th, I'll bet you less than 2% of Americans can talk about their 9th and 10th Amendment rights, the unenumerated rights, and those rights that aren't specifically given to the federal government are reserved for the states and the people respectively.
And we really ought to pause, because people ought to take a look at the 9th Amendment. The language is fantastic.
It's great.
You look at the 9th Amendment, it says, hey, look, you could summarize the 9th Amendment by saying, look, just because we said you got all these rights, we don't want anybody to think there's not a whole bunch of other rights out there that we just haven't enumerated. Your right to smoke weed, your right to say marry who you want, your right to have sex with who you want. There's a whole host of rights out there. Guess how many the courts have found in the 9th Amendment?
None.
Can you believe it?
It drives me nuts.
I find it disgraceful.
I do
but even fewer attorneys would talk about the 9th Amendment, because there's really nothing to talk about. It basically means nothing, which I think is a disgrace. But if you look at the back of my card, you'll notice that I have people assert their 9th Amendment rights as well. But that's an aside. The Fourth Amendment protects your right to be free from an unreasonable search and seizure. Keeping in mind, like all of these other rights, it's just a piece of paper, right? And the Supreme Court decides what they mean. I like to sometimes recast the Fourth Amendment in a way that I think helps people understand it. And here's how I say it. The government can search or seize anyone or anything, anytime it chooses for any reason at all, so long as the government decides that what the government did was reasonable.
That sounds terrible.
Doesn't that sound horrible?
That sounds horrible.
That's about what it really means. The government gets to decide. What do I mean by that? The courts, the government courts get to decide. And all they're really deciding is exactly the same thing that we're always talking about in the self-defense context. What are we always talking about when we're talking about self-defense? Reasonableness. I'm always hitting you over the head and saying, if it's reasonable, it's going to be fine. If it's unreasonable, we're trying to predict that, right? We have some rules that lay out some general guidelines. The same is true in the Fourth Amendment context, that you're protected from an unreasonable search and seizure. So what's an unreasonable search and seizure? Well, generally speaking, if the government wants to search or seize, they got to get a warrant. Okay, we like the idea of warrants because we don't want the typical cop out on the street making decisions about when they can search your house normally. So the general rule is, you want to search or seize, go get a warrant.
Go to the judge. Swear out a warrant.
Swear out a warrant. It's called the affidavit. You swear it out. Here's all the facts. You give that to the judge. The judge then reads that and decides, is there probable cause to believe that, the fruits of some crime are in the house or something like that. The judge then signs the warrant, gives it to the cop. The cop then has now the permission of the judge to go search. That's fairly easy, right? Then come the exceptions to the warrant requirement. And there are a whole host of exceptions to the warrant requirement. All of them, I would say, have a sort of reasonable basis to it, right? Like, for example, if the cop makes an arrest, do we want him to go to the judge to get a search warrant to search you for, the pat down and to make sure you don't have a gun in your pocket as he's taking you to jail? That seems a bit unreasonable, right? So we've developed an exception to the warrant requirement for what we call the search incident to a lawful arrest. Mm-hmm. There are many other examples. There's sort of the hot pursuit exception, right? You're chasing the felon after he just robbed the bank and now he runs into the house. Well, you don't have to go to the judge and get a warrant. Because you're in hot pursuit, you can continue the hot pursuit. So there are many sort of exigent circumstances type exceptions.
Preserving life, those kinds of things.
Many such things, and they're all turning on what the court decides is reasonable, right? So those are the various exceptions. Then we get into one that I think is completely wrong and should be totally abolished, the vehicle exception. Let me tell you what the concept here is. The concept here is, vehicles are movable. People can drive away with the vehicle. Mm-hmm. And if the police officer has what he believes is probable cause, which in the context of our humongous drug war, which has basically, if anything, has caused the destruction of the 4th and 5th and 6th Amendment, you can hang that on the drug war. That's another discussion for a different day.
Good discussion, but not for today.
Say the police officer has the odor of marijuana. He now has probable cause to believe that there is drugs inside the vehicle. Well, the old school, put yourself into the 1950s, 1960s. What do we want to do? He's got to go get a warrant from the judge. That's going to take a long time. This guy's going to drive off. The evidence is gone. There's a problem here, right? So we create this thing called the vehicle exception. Originally, it came in with probable cause plus exigent circumstances, and the exigent circumstances are the fact that the vehicle can be driven away. But as you fast forward to today's world, where the police officer can just simply go to his car and type up a few things, and over the internet or a secured system can request a warrant from a judge, and in minutes, very routine today for police officers to get search warrants in minutes. They do it all the time.
Sure.
In Arizona here on DUI cases. When they say, hey, can we take your blood? And you say, absolutely not. And they say, well, we're going to get a warrant. This doesn't take them very long. They do them all the time. It's really simple. So because of this change in technology, I don't think we need the vehicle exception anymore. I think they should still have to get a warrant. But the state of the law right now is that if the cop has probable cause to believe that there's, say, contraband or something inside the vehicle, that's an exception. It's a huge gaping hole exception. This is where the cop tears apart the car, opens the trunk, through the whole 9 yards. Now, in the example that you were bringing up before, another huge gaping hole in Fourth Amendment law is consent.
Yeah, because once you consent to a search,
the analysis is off the table now. We don't need to analyze it because you have consented. You have given up the Fourth Amendment, your Fourth Amendment right to be free from unreasonable searches. And I can tell you, the vast majority of criminal cases, that's probably the way they get the evidence. And so, as you mentioned, guy gets pulled over, he's got expired tags or something, and we find he's got now illegal weapons in the car. Unless they were in plain view, because the courts will say this is yet another exception, right? If it's in plain view, if the police officer is standing at what we call a lawful vantage point, they had a right to be standing where they're standing. So if they enter your house without permission and they see something, that's a problem. But if they're standing on the side of the road after a valid traffic stop and they're looking in the car and they can see something that's immediately apparent to them as an illegal weapon, because maybe in this state, it's an AR-15 or something, and AR-15s are illegal or something like that, they can tell immediately. They can then take that because they don't need to get a warrant. It's in plain view. So consent is probably, my guess here is, unless it was in plain view, probably the officer said, is it okay if I search your car? And this guy foolishly said, sure, no problem.
Whatever.
So here's how I like to explain it to people. If the police officer is asking for your consent, that means they probably need it.
Yeah, it means they need it.
Because if they had an exception to if they had a search warrant, they don't ask your permission when they have a search warrant.
Nope.
If they had an exception to the warrant requirement, they don't generally ask your permission on that either. They're just going ahead and doing it. So if they're asking you, if they're saying, is it okay if I search the XYZ? what you should hear is they got no other legal basis to search this.
Yeah, they think they might want to find something, and so they're asking you to give them permission in.
They're fishing.
They're fishing.
Why would you give up your Fourth Amendment rights like that?
And listen, I have a lot of friends who are cops, and I get it. They fish a lot in ponds where they think they're fish. And so if they think this guy's probably a bad dude, I'm going to fish a while and see if I can catch some, because they catch a lot of bad people doing stupid things.
Right.
And I get that, and I think that's valid, because you can ask, right? And if they say yes, okay.
Another very important point along the same line of reasoning is there's a big difference between a police officer saying, hey, that's a nice shirt, where'd you get that? And sort of striking up a conversation with you. That's what we call a voluntary interaction with the police. If it's in the voluntary interaction box, we're not talking about the Fourth Amendment.
Nope.
You're having they can ask you anything they like. Would you, where did you get this shirt? Do you have other shirts like it? Would it be okay if I came to your house and looked in your drawers just to check out your shirts? Is it okay if I strip search you? Is it okay? If you say yes,
then we're having a consensual time.
We're not talking about the Fourth Amendment at this point. It's a consensual conduct. Now, sometimes it's hard to tell, right? When the officer says, excuse me, I'd like to ask you a question. Or hold on a second, I'd like to ask you a question. I'm going to tell you that, the test under the law is going to be, would a reasonable person feel free to say, no thanks, I'm going to keep going this direction? If the answer is a reasonable person would have felt free to disregard the police officer or walk the other way, then you're dealing with a voluntary interaction. If the person would not have felt free, and in the case where an officer says, hold on a second,
wait a minute,
I want to talk to you, that's enough to get us into the Fourth Amendment analysis. So in the case of the officer says, hold on a second, I want to ask you some questions, he needs to justify that now under the Fourth Amendment. And what the courts have said is, if it's a brief detention under the Terry case, Terry versus Ohio, everybody knows about that case, then what they need is something called reasonable suspicion. Reasonable suspicion that crime is afoot.
Crime is afoot.
Whatever that means.
Would a reasonable officer, with the officer's training, believe that crime is afoot?
And contrast that with Delaware versus Prowse, a case where a very honest police officer got up to stand and on the stand and asked him, why did you have this interaction with this person? He basically said, I just had a hunch.
Yep.
Not good enough.
Not enough.
Not enough. You need more than a hunch. We don't know exactly what reasonable suspicion is. The courts have refused to give us sort of a mathematical formula. They don't. Probable cause, you might think, would be more than 50% likely to be probable.
Yes.
But the courts have never said that.
Yeah, but it's a rule, general thumb.
Courts have said it could be far less than 50% and still probable.
Yeah.
So it's very squishy standard.
It is.
But generally speaking, police officer makes a traffic stop, police officer says, hold on, I want to ask you a question. That's going to be a reasonable suspicion standard. Police officer now wants to detain you for an extended period of time or put cuffs on you or move you somewhere. You're talking probable cause, something in higher.
Yeah.
So they've got to get something in that initial investigation that heightens their suspicion.
Well, and of course, I know here in Arizona and a lot of other places, an officer, if it's a non-consensual, well, I guess even in a consensual thing, he can ask, hey, are you armed? And in Arizona,
they can always ask if you're armed. That's
you
a
have to
voluntary
answer that honestly.
Yes, in Arizona, you do have to answer that question. I think the law's wrong. I think it runs afoul of the Fifth Amendment. I'm waiting for a case to bring that up. I'm not aware of any case here that's challenged. There are two parts to this. I think both of them probably are unconstitutional, but neither has been found unconstitutional, which is step one. The officer gets to ask you, now that he's detained you, do you have a firearm somewhere on you or in your vehicle? You have to answer that question. I think that violates your Fifth Amendment right to remain silent. And then number two, if you do have a gun, they get to take it.
Yep, they do have.
And they get to hold it during the traffic stop. Now, this is all justified under the sort of officer safety rubric, but my response to that is too bad. I mean, citizens are armed. They have a right to be armed. And our Constitution, both the Fifth and the 14th Amendment, state that the government doesn't get to take your property without due process of law. And so what is it, when they take your gun, they're certainly taking your property.
They have detained my property.
I don't think there's been any due process. All that's occurred is they found out you had it, and now they take it. It's not a huge transgression, but I think it is a violation of the Due Process Clause, 14th and or the 5th, depending on whether you're dealing with federal or state.
Well, and but there's even more protection under the fourth. So that immediate thing of, okay, for officer safety, he's going to search you for weapons or whatever. Even that's not, I mean, you can say, listen, that's a pat down on the outside, looking for weapons or whatever, but whatever else you have on you, that still even more has to have.
This is also another interesting area. You know, it's hard to communicate this stuff unless you've sort of read the cases and seen how things have evolved. But when Terry was decided, there were really two separate inquiries here. One was the reasonable suspicion to detain. The other is this reasonable suspicion for the pat down of the outer layer of clothing, which you don't often see, right? The officer will do this little pat down thing. Well, the justification here is that, and was in the Terry case, is that the officer has reasonable suspicion to believe two separate things. Number one, you're armed. And number two, you're dangerous.
And dangerous.
Right? Because, as you would say, and I would agree, just because you're armed doesn't necessarily mean you're dangerous. And so what this has sort of morphed into over the years, I believe that most police officers believe that whenever they make a Terry stop, they get to automatically do a pat down for weapons. They think the two kind of go together. Some believe, no, that's just for weapons, but they believe that, well, if he's got a weapon, I can pat down to see if he has weapons. I still don't think that's enough. I think they got to have some grounds to believe that the person not only is armed, but is also dangerous. Without the dangerous component, I mean, should we just pretend that every time someone's armed, they're automatically dangerous? I think that's ridiculous.
And in my experience, even here in Arizona, where we have these kind of interesting laws, the couple times that I've had, been pulled over, once for expired registration, once for a speeding ticket, it happens, right? Okay, are there any weapons in the car? Yeah, there sure are. Oh, okay, do me a favor, don't touch them. No problem. I'm not, I'm a good person. I'm not going to mess around with that. I get it. So I haven't had any problem. In fact, one of them I had just helped a friend out. I literally had 25 guns in the car when he got pulled over. There are weapons in the car? Boy, this is going to be an interesting explanation, sir. There's like 25 guns in the car right now. What the heck happened? Well, so here's what went down. I helped a friend out, bought a bunch of guns from him. Okay, whatever. I don't even want to talk about it. Just leave them where they're at, okay? Sure, no problem. No problems there. But so getting back to the point here at the end, so do you suggest that people then really stand on and assert their Fourth Amendment rights then, Mark?
I totally do. There's no downside whatsoever to just say, hey, if they're asking, is it okay if I search blah, blah, blah? I say find a nice, kind, not offensive way to communicate to the police officer no, right? If you say, I hate cops, and screw you, and
screw you, pig. Yeah, no, bad.
You're asking for problems, right? Because there's a lot of discretion for the cops on the side of the road.
Right.
How long they're going to detain you, like the gun question, right? They didn't have to take your guns. They gave you a break. He could have been a pain in the neck.
Could have been a pain.
Right.
Could have gone through all 25.
Find a very nice way to communicate to the officer. And if you want, blame me. You can say, I always tell people, blame me. I got a buddy. His name's Marc Victor. He's a criminal defense lawyer. He'd kill me if I consented to a search. But so sorry. If you feel like you have a warrant or something, you get a warrant, then I understand, or something like that. But I do not consent to any search.
Right.
And also the other question I think is a great one to ask, because it's very confusing sometimes about whether you're free to leave. This is saying another way. Am I being detained or am I in the voluntary interaction box? The best way to get to the bottom of that is say, am I free to leave? Because then you force the issue, right?
Yeah, you don't want to be a sovereign citizen. Am I being detained? No. Am I free to leave?
Am I free to leave? Because if the answer is yes, then have a great day, officer. Bye-bye. If the answer is no, now we know you're being detained. So what you've done is you've helped your criminal defense attorney now make the argument that we know that they got to produce reasonable suspicion or this is a bad stop.
Two key phrases here. Am I free to leave? Number two, I do not consent to any searches. I do not consent to any searches. That way your rights are protected to the maximum extent possible. Mark, appreciate the time, man.
Happy to help.